Hola a todo el mundo, bienvenido a mi canal. Yo me llamo Sirey. Soy una abogada afro-latina licenciada practicando la ley criminal, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a continuar nuestra conversación de Luigi Mangione. Si quieren más video en español, nada más dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latina criminal attorney who, much like the rest of you, has a severe fascination with true crime cases. Listen, you guys, I'm making this video solely for the purpose of gloating. Can I gloat? Can I gloat? But really also for the purpose of verification. I've mentioned to you guys before, I don't want to be your saving grace. I don't want you guys to look at my videos and just take my word for everything that happened. I want you to do your own research. I remember a few months ago, or maybe a few weeks ago, probably a few weeks ago, I did a video on Luigi Mangione, and we talked about the fact that his defense attorneys filed a motion to suppress. Specifically, they were looking to suppress all of the evidence that was obtained from his backpack, citing that the police officers did not have a warrant. We talked about some of my initial opinions on it without going too deep into the case. I remember talking about searches incident to arrest. I talked about officer safety, but in essence, I talked about that there was numerous exceptions to the warrant requirement that would have made this search valid. Now, without any further ado, the court in this case issued their ruling and they denied Luigi's motion to suppress, kind of like I thought they would. Let's get into it. Defendant Luigi Nicholas Mangione has moved to suppress the search of a black backpack recovered from him at the time of his arrest on December 9th of 2024 and all items contained within. For the reasons that follow, that motion is denied. First, the Fourth Amendment protects individuals from unreasonable searches and seizures, and absent an applicable exception, the law generally presumes that a judicially authorized warrant is required for a search to be reasonable. While a safety search is most commonly applied to a search of a detainee's person when he or she is taken into custody, courts have also recognized that the exception can apply when officers have reason to believe that a bag or other closed container that must be transported in a police vehicle may contain some immediately dangerous objects such as an incendiary device or noxious chemicals. In such circumstances, officers may conduct a warrantless search of the bag to the extent necessary to confirm the presence or absence of immediate danger. Such a search was reasonable under the facts of this case. At the time of his arrest in the McDonald's, the defendant was suspected of being the person who had gunned down a stranger on a street in Midtown Manhattan, using a handgun equipped with a silencer and leaving behind shell casings that had been inscribed with the words "delay, deny, and depose," an apparent reference to the victim's work as the chief executive of a private health insurance company. The circumstances clearly suggest at least the possibility of a political or ideological motive to send a public message through the use of violence about the health insurance industry, and little was otherwise known about the perpetrator, including whether he had acted alone or as a part of a group, and whether the Thompson murder was an isolated incident or was part of a larger plot contemplating further violence. Police need not have certainty or even probable cause to take steps to protect themselves and the public so long as their actions and the suspicions that prompt them are reasonable. Under these circumstances, police were justified in conducting a safety search of the backpack before it was transported. Such a search would also be consistent with the established principles and training of the Altoona Police Department. Here, the backpack was opened at the McDonald's before transport and a cursory search was conducted, as the officer can be heard on her body camera stating that she needed to be sure the bag did not contain a bomb or anything before she put it in her car. While feeling around inside the bag for items that could be dangerous, the officer also immediately pulled out a heavy metal item wrapped in an article of clothing, which turned out to be a loaded handgun magazine. In sum, the loaded magazine is admissible as the product of a reasonable pre-transport safety search. Inventory searches, meaning searches conducted of property in the custody of the police in order to identify and log anything that the police are responsible for storing or safeguarding, are another well-defined exception to the warrant requirement. Inventory searches do not violate the Fourth Amendment because their goals are unrelated to the warrant requirement or the necessity of probable cause. Rather, they serve to protect an owner's property while it is in the custody of the police to ensure against the claims of lost, stolen, or vandalized property and to guard the police from danger. danger. To be valid, inventory searches must be conducted using standardized criteria or established routine. A police department's standardized procedures may be established by written rules and regulations or by testimony regarding the department's standard practices. Here, Deputy Chief Snyder's testimony and the exhibits offered at the suppression hearing amply establish that the Altoona Police Department has written procedures and rules regarding the searching and inventorying of any property brought into the police station and that officers are trained in these standards. The search of the backpack at the Altoona Police Department falls within the inventory search exception, and therefore its contents are admissible on this basis as well. Finally, however, even if the defendant were correct that it was not reasonable for officers to conduct a pre-transport safety search of the backpack, and thus that the loaded magazine would have not been discovered at the McDonald's, or that under established inventory search procedures of the Altoona Police Department, any search should have stopped in favor of a warrant as soon as one or more of the loaded magazine, firearm, or silencer were discovered. The contents of the backpack are still admissible in light of the December 15th federal search warrant under the inevitable discovery doctrine. The exclusionary rule is a court-made doctrine that generally requires evidence obtained in violation of the Fourth Amendment's warrant requirement or a recognized exception to that warrant requirement be suppressed and not offered as evidence at trial. It is a prudential doctrine that is remedial and intended to compel respect for the constitutional guarantee. The doctrine of inevitable discovery is an exception to the exclusionary rule first recognized by the Supreme Court in Nix v. Williams, which identified the exception as closely related and functionally similar to the independent source doctrine, another exception to the exclusionary rule. The independent source doctrine allows admission of evidence that has been discovered by means wholly independent of any constitutional violation, because exclusion of such evidence would not serve the exclusionary rule's deterrent purpose. Instead, exclusion would put the prosecution in a worse position simply because of some earlier police error or misconduct, thereby upsetting the balance between the interest of society in deterring unlawful police conduct and the public interest in having juries receive all probative evidence of a crime. In Nix, the Supreme Court applied the same reasoning to endorse the inevitable discovery doctrine as the extension of the independent source doctrine. If the prosecution can establish, by a preponderance of the evidence, that the information ultimately or inevitably would have been discovered by lawful means, then the deterrence rationale has so little basis that the evidence should be received. Anything less would reject logic, experience, and common sense. The inevitable discovery doctrine allows the fruits of an illegal search or seizure to be nevertheless admitted at trial if the government can prove that the evidence would have been obtained inevitably without the constitutional violation. The government bears the burden of proving inevitable discovery by preponderance of the evidence. Proof of inevitable discovery involves no speculative elements but focuses on demonstrated historical facts capable of ready verification or impeachment. The focus on demonstrated historical facts avoids undue speculation by requiring the district court to determine, viewing affairs as they existed at the instant before the unlawful search, what would have happened had the unlawful search never occurred. Evidence should not be admitted, therefore, unless a court can find, with a high level of confidence, that each of the contingencies necessary to the legal discovery of the contested evidence would be resolved in the government's favor. In this case, the first violation the defendant alleges is the pre-transport safety search in which the loaded magazine was recovered was not justified. However, the record clearly establishes that the backpack was taken from the McDonald's by the Altoona Police Department as part of their standard safeguarding procedures for the personal property of a person arrested in a public place, and there is no doubt that the backpack would have been transported to the police department even if the pre-transport safety search had not occurred, or the initial cursory search had failed to turn up the loaded magazine. Once at the station, the record also clearly establishes that the standardized procedures of the Altoona Police Department would have required that the backpack be opened and its entire contents inventoried and logged. The Mendez factors govern when inventory search procedures can establish the grounds for inevitable discovery. 1. The police had legitimate custody of the property being searched so that an inventory search would have been justified. 2. When the police in the police agency in question conducted inventory searches, they did so pursuant to established or standardized procedures. And 3. That those inventory procedures would have inevitably led to the discovery of the challenged evidence. Even if the defendant is correct that the standardized procedures of the Altoona Police Department would have required that any inventory search stop in favor of a search warrant once the loaded magazine, the handgun, and/or the silencer were found in the backpack in the course of the inventory search, a search warrant was in fact obtained, first by local authorities, and then more importantly for our purposes, by the federal authorities prosecuting this instant case. Conclusion. In sum, numerous exceptions to the warrant requirement, as well as the federal search warrant actually issued, preclude exclusion of the backpack and its contents in this case, whether through the discovery of the loaded magazine during a pre-transport safety search, the recovery of the remaining items in the course of an inventory search at the police station, or the inevitable discovery of all the contents through the federal search warrant, even excising references to any items found or seen after the magazine, firearm, and/or silencer were found. Accordingly, the motion to suppress the backpack and its contents is denied. Okay, so you heard it from the judge herself. First, she says that the officers needed to do that for their safety. Now, why is safety so important? As she mentioned, Luigi is not a person who was accused at the time of running a stop sign or driving above the speed limit. He was accused of murdering a stranger, and some parts of the murder had to do with the stranger's occupation, right? So it is reasonable for officers to assume that there could have been dangerous contents in his backpack. And because of that, this exception to the warrant requirement allowed the officers to search the backpack while at the McDonald's. Let's assume you don't buy that argument. Let's go to the second valid point that the court made when denying Luigi's motion to suppress the contents of his backpack. I haven't talked to you guys about inventory searches much, and I think that's because I don't really think of them. They are valid exceptions to the warrant requirement, but in most of my cases, warrants are issued. So let's just talk about what an inventory search is. Whenever someone is being arrested, someone who's accused of a crime is getting arrested. When they get down to the police station, the officers will then inventory whatever property they have on their person, meaning he had the backpack. For officers' awareness, or for the awareness of the person should they otherwise be released from custody, they will take inventory of all the items that are in the backpack, meaning, Luigi had some gum. He had this gun. He had $50, whatever. So that way they know if you were to be released, the items that are going back with you are everything that were received when you came in. And because of that, it's valid that they located the magazine, the firearm, and the silencer. But let's say you don't buy that either. Let's talk about inevitable discovery. The inevitable discovery doctrine states that if the items would have nonetheless been recovered otherwise, despite any error or errors on behalf of the police, then that evidence is still admissible. So what the court is saying here is, let's assume that defense is right. And let's assume everything you're saying is right and they needed a warrant before searching your backpack. They eventually got one and still got all the contents out of your backpack. So it does not matter if they search your backpack and found all of those items prior to having a search warrant, because then they got a search warrant and they lawfully obtained all of the items anyway. Does that make sense? So all in all, to say, I anticipated that the court would deny defense's motion, but as I said in my last video, I wasn't really surprised that the defense made these arguments. They were valid arguments to make. I think that this case is gearing up to be a rather interesting one, and we will keep apprised of everything that happens in this case, or as long as you want me to keep apprised of this case, as long as you want me to keep you updated. So just let me know anything it is you want to let me know down below. As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.